Welcome to Business Recipe. Every business has a recipe. Here's theirs. Today's recipe, the venue you used to go to. If it's already closed, Tom DeGeorge could tell you why. 20 years running his in Tampa, closing July 31st. And everyone assumes it's the rent. The rent part is true. But in May, he told Congress there's a fourth reason. And in April, a federal jury had already proven him right. Here's the recipe. Live Nation owns the amphitheaters. Ticketmaster, its own subsidiary, sells the tickets. Together they touch nearly every major show in America. This isn't a story about ticket fees. You've heard that one. It's about what happened when the government finally sued them, then quietly left the room before the trial ended. Ingredients: how one merger built a monopoly regulators had already caught cheating once. Method: how you squeeze out a 300-person room without breaking a single law on the books. Result: a settlement signed in March and a verdict that landed in April. In that order, which is the whole point. And who ate it? The man from the hook and the 20 years he's about to lose. Hold on to that order. We're coming back to it. Every recipe starts with what's already in the kitchen. In 2010, the Justice Department let Live Nation and Ticketmaster merge on one condition: a 10-year consent decree promising the new company wouldn't punish venues for using a rival ticketing service. They broke that promise almost immediately and kept breaking it into 2019. When regulators caught them again, Live Nation didn't get punished. It got a second chance. DOJ extended the decree 5.5 more years, added an outside monitor, and set a $1 million fine for every future violation. That same decree, from 2019, had already required Live Nation to put a whistleblower protection policy in writing. Nobody expected to test whether the company actually meant it. By then, the shape of the business was already visible in its own numbers. 78% of the large amphitheaters touring artists actually use, and 86% of ticketing at major concert venues, according to the government's own complaint. In 2024, the Justice Department and a coalition of states sued again. The same conduct, a second time, inside a decree that was supposed to have already fixed it. 1,000 miles from that courtroom in Ybor City, Tampa, none of this had a name yet. It just had a bar. Tom DeGeorge had been running Crowbar for 2 decades. 300 capacity, the kind of room where a local band opens for whoever's about to be famous. He wasn't a plaintiff. He wasn't a lawyer. He was about to become the ingredient nobody in that courtroom had budgeted for. Here's the method, and it doesn't require breaking a single rule. DeGeorge described it to Congress in plain arithmetic. Live Nation can overbid, lose money on shows, and absorb it all because they make billions through Ticketmaster and every other part of this industry. A show that loses money is a rounding error if the same company also sells the tickets, runs the parking, and owns the room next door. This April, Live Nation announced a new venue for Ybor City, 4,300 capacity, 14 times the size of Crowbar's 300 seats. It doesn't need to outsell Crowbar. It only needs to outlast it. The same playbook shows up from the inside, too. Nicholas Roumanis, a former Live Nation development executive, is now suing the company for $35 million, alleging he was fired after flagging a no-bid 25-year exclusive booking deal on a Michigan amphitheater. Structured, his suit claims, with an upfront payment designed to dodge the competitive review a public venue deal should get. Live Nation disputes it and says he uncovered no fraud. Whistleblower protection policy or not, that's the case that will decide whether 2019's promise meant anything. And the method has a voice on the record. In 2022, Ben Baker, Live Nation's head of ticketing for its amphitheater division, wrote to a colleague on Slack about parking and VIP fees. Robbing them blind, baby. That's how we do. On the stand in 2026, he called his own message indefensible. His boss, CEO Michael Rapino, told the court it was disgusting and not the way we operate. But the way we operate has its own paper trail. In a 2019 deposition, Rapino described the company's real strategy without the euphemism: an incredible moat around the castle, built to keep competitors out. 3 years before that, in a private email, he'd already admitted, "Our fees are too high. We can't defend them." The method was never a secret. It was just never said in front of a customer. Here's what came out of the oven. And the order matters more than the ingredients. The trial started March the 2nd, 2026, in a Manhattan courtroom in front of U.S. District Judge Arun Subramanian. 3 days in, while the jury was still hearing evidence, the Justice Department reached its own settlement with Live Nation and walked away from the case it had built. The deal wasn't signed in that courtroom. According to Live Nation's own later filing, it was signed March 5th at the White House, in a meeting that included Live Nation's CEO, the company's lawyers, the Antitrust Division, the Attorney General's office, and White House counsel. A term sheet finished in a single sitting. The court didn't hear about it for 4 more days. When the terms became public March 9th, they added up to this: a $280 million fund, a 15% cap on Ticketmaster's own fees, exclusive booking rights divested at 13 amphitheaters Live Nation still owns, and no breakup of Ticketmaster itself. 6 states signed on. 33 states, plus Washington, D.C., refused and kept litigating alone. Rapinoe called it a major step in improving the concert experience for artists and fans throughout the United States. The 33 states disagreed enough to spend 5 more weeks in court proving it. Before we go further, the strongest case for the other side, because it deserves the full argument, not a straw man. First, this settlement isn't nothing. A 15% fee cap, forced competition on half of Ticketmaster's own inventory, exclusive booking rights gone at 13 amphitheaters. Those are real enforceable changes, and Rapinoe has said publicly the company competes on the best products, services, and people, not exclusivity. Maybe DOJ read the litigation risk correctly. 5 weeks of trial, 33 state attorneys general, and even then the states only proved a 1x72 per ticket overcharge, not the kind of number that guarantees a breakup. Settling early could be read as simply pragmatic. Second, Live Nation's own post-trial motion argues the jury was moved by emotion, not law. Testimony about parking fees and lawn chair rentals, they say, standing in for a legal case that should have turned on market definitions alone. That's a real argument lawyers make, and judges sometimes agree. Here's what breaks both arguments. A pragmatic read of litigation risk requires knowing the risk. This deal was signed March 5th, 5 weeks before the jury ever reached a verdict. Nobody at that White House meeting knew whether the states would win 1.72 a ticket or nothing at all. And Roger Alford, a former DOJ antitrust official who was in the government at the time, later testified before members of Congress. Senior officials in Pam Bondi's office overruled us because of recommendations from lobbyists that have no idea whatsoever about the antitrust laws. You can't settle to avoid a risk you haven't measured yet, unless the risk was never really the reason. Now for the turn, because everything so far has been leading to one date. April 15, 2026. 5 weeks after the DOJ walked out of that courtroom, the jury the government had abandoned came back with a verdict. Live Nation and Ticketmaster. Liable. On the federal monopoly claims DOJ itself had originally filed, and on the state's own antitrust laws alike. 1.72 overcharged on every ticket, on top of everything else the jury found. A separate trial, still ahead, will decide whether Ticketmaster itself has to be broken up. Remember the man from the top of this video? By his own account, Crowbar's closing isn't about one thing. It's the rent and the parking, both climbing for years. It's a failed attempt to buy his own building. It's a business that never fully recovered from being shut down in 2020. Every one of those is true, and DeGeorge says so himself. But 5 weeks after that verdict, he stood in front of Congress and named the reason those other 4 don't fully explain. Live Nation can overbid, lose money on shows, and absorb it all. There is no level playing field with a monopoly. He called the company the hogs at the top. Then he told lawmakers something the jury's verdict couldn't put in a headline. After 20 years, my venue will close on July 31st of this year. This is exactly why this channel exists. To show you the mechanism before the headline simplifies it. If that's useful, subscribe. Here's the turn. DOJ's settlement wasn't a reward for a verdict that favored Live Nation. It wasn't a punishment for one that didn't. The deal was signed March 5th, filed to the court March 9th, and the jury didn't rule until April 15th, over 5 weeks after DOJ had already decided what leniency was worth. The government's mercy was never a response to the trial. It was scheduled before the trial had an answer to respond to. That fight isn't finished, either way you look at it. Live Nation has asked the same judge to erase the verdict entirely. As of this recording, that motion is still unresolved, with arguments set for July 29th, and DOJ's own settlement is still sitting in a mandatory public comment period that doesn't close until early September. Whatever happens in that courtroom next, the sequence that already happened doesn't change. The government's leniency came first. The proof came after. And it was never waiting on the proof at all. 3 signs this pattern travels well beyond one industry. Sign 1, count the promises, not just the punishment. Live Nation signed its first antitrust promise in 2010, broke it, and got a second one in 2019 with a monitor attached. The 2026 settlement is promise number 3. When a company is on its 3rd consent decree, the decree isn't the deterrent anymore. It's the cost of doing business. Sign 2. Look for the math that makes losing profitable. Nobody at Live Nation broke a pricing law by building a 4,300-seat room next to a 300-seat one. They just made sure the room didn't have to win on its own. The company around it would cover the loss. If a competitor can lose money on the exact thing you sell and still come out ahead, you're not in a fair fight. You're in their supply chain. Just ask the public arena boards that signed no-bid deals without ever finding out what competitive bidding might have gotten them. Sign 3. Check what came first, the leniency or the verdict. If a settlement is signed before the outcome is known, it was never a response to that outcome. It was a decision made in spite of not knowing it yet. That's not a defense. That's the tell. You're not looking for the moment a company got caught. You're looking for the moment it stopped being afraid of getting caught. On July 31st, Crowbar closes for good. Talib Kweli headlines the last show, the same performer who once did an unplanned reunion set on Crowbar's patio back in 2011. 300 tickets for a room that's closing partly because a 4,300-seat one was announced nearby, and partly for reasons that have nothing to do with any of this. A documentary crew has been filming DeGeorge for months, trying to capture what 20 years in one room actually adds up to before the room is gone. Live Nation will keep operating exactly as it did the day before the verdict, while a judge decides what happens next. If this recipe changed how you read the next Monopoly headline, that's what this channel is for. Subscribe to Business Recipe. Next time, a company that figured out how to make the government its biggest customer and its softest regulator at the same time. Today's recipe, complete. So, what business should we crack open next? Drop the company name in the comments. We read them. If you want more case studies like this one, subscribe. New recipe every Tuesday.